Hello, I'm Dominic Walker, JMW's Inside Man. My guest is Mark Wells. Mark is an associate solicitor within JMW's commercial litigation department. Mark, what is unfair prejudice?
Hi, Dom. Thanks for having me on. Unfair prejudice, or unfair prejudice proceedings, is the shorthand title given to what is properly known in the court vernacular as a shareholder's unfair prejudice petition. Basically, any shareholder in a company who feels that the company is being run in a manner which unfairly prejudices, and that's where we get the name, their interests as a shareholder, has the right to petition the court to intervene in the company's management. In reality, what most people would recognise as unfair prejudice proceedings is something akin to a divorce, only between business partners as opposed to a married couple. Because essentially, if you're in a situation where you're having to issue proceedings, the relationship between shareholders in a company must have broken down to such an extent that continuing working together is completely impossible, and a third party's intervention is necessary to prevent the relationship breaking down, becoming absolutely ruinous for all concerned.
What are the remedies?
Unfair prejudice proceedings are interesting in that once a court is satisfied that unfairly prejudicial conduct has taken place, it has the scope to make almost any order regulating a company's affairs that it wants to. And that's quite literal. It can do almost anything it wants in the management of the company. The most usual order sought, and the one that anyone who's vaguely familiar with the proceedings might recognise the most, is what's called a purchase order, where in that what you'll have is a petitioner, who is the party alleging the unfairly prejudicial conduct, or the respondent, the person replying, asking that the court make a purchase order for one or the other's shareholding for a specific sum. So the petitioner might be saying to the court, my share in this company has been affected by this person's conduct, and at the date that the conduct started, my shareholding was worth X, and because of the conduct, it is now worth less. And so what I want is the court to order that this person buy my shares out at the price that they were before they started misbehaving. Or they might think, well, actually, I think I can run this company better than they can. So they say to the court, they've decreased the value of the company, so they shouldn't be rewarded for that, but I should be allowed to buy out their shares at this decreased value, so I can then go off and run with it. But what is important to note is that just because that's the usual order sort, as I've already referred to, a court can do anything it wants, and a court is absolutely not guaranteed to do what it's asked to do. Recently, we acted in proceedings within the firm in which the court actually decided the most appropriate order was to leave all the parties in business together, but with an order in place regulating how they're going to run the company. So for this reason, we would normally say it's really important for people who might find themselves in this situation to seek legal representation quite early on in situations when there's a breakdown of shareholder relations, because once proceedings are issued, if they do progress through to trial, no one can count on a judge ordering what they want. But that's why it's always preferable to reach and negotiate a settlement if possible.
And so anybody watching this who kind of think, well, hang on a minute, this rings a bell, I'd like to bring this sort of litigation, or conversely, somebody who's trying to defend this sort of litigation, what can they do? Can you help, Mark?
Yeah, so basically what we'd say is that anyone who's watching this who is either in a shareholder dispute themselves or knows of anyone who is, I would suggest they get in touch with us. People seem to have a misconception that, especially in matters like this, you see a lot of correspondence which reads to the effect of, once solicitors get involved, parties get entrenched, costs build up, and what have you. And I just think that just doesn't reflect our experience at all. Our role, and it's one that's specifically encouraged within JMW, is to focus on dispute resolution rather than escalation. And often the earlier a matter that is brought to our attention, the better for all parties concerned.
Mark, thank you very much for your insight. And if you'd like to contact Mark and the team, you can email insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.